In breaking news, a federal magistrate judge has found that Lindsey Halligan, the prosecutor of James Comey, and New York Attorney General Letitia James likely made two fundamental errors in violating the Fifth Amendment and the burden of proof, the Sixth Amendment of the Constitution, in presenting her first case to a grand jury to obtain the indictment of James Comey. Magistrate Judge Fitzpatrick has reviewed the transcripts, and he's made those findings along with 9 other ones about how the government has violated the rights of James Comey, which could lead to an immediate dismissal of his indictment. And just as we suspected, the affidavit or the declaration that Lindsey Halligan just filed in the last 48 hours in the other case to try to save her job, because Judge Curry, another judge, is deciding whether she was illegally appointed. That affidavit was used by this magistrate judge to say that she also is incredible with her testimony and couldn't possibly have gone back in with the grand jury and fixed her errors because she admitted that there was a 2-hour gap in which she didn't talk to the grand jury. I love when somebody's declaration in a related case gets used by a magistrate judge in this matter. Oh, what a tangled web we weave. I'm Michael Popok. You're here on Legal AF on Monday. We've been waiting for this order. The judges involved to set the stage. Judge Nachmanoff is the judge, the Article 3 judge who presides over the entire case. Magistrate Judge Fitzpatrick is the judge who deals with issues referred to him by Judge Nachmanoff. Now, Judge Nachmanoff said, I see the defense wants the grand jury transcripts. That is unusual, but if you can make findings sufficient that they need these transcripts in order to support their motion to dismiss the indictment, then you, magistrate judge, are to order it. There is a rule that covers this. It's the Federal Rules of Criminal Procedure, Rule 6 about grand juries. And if you go to Rule 6, little e, number 3, big E, little 2 in the whole, it says the following: the court may authorize disclosure at any time in a manner and subject to any other conditions that it directs of a grand jury matter at the request, and this is now you go down to the little 2, at the request of a defendant who shows that a ground may exist to dismiss the indictment because of a matter that occurred before the grand jury. And the judge got the transcripts, the same transcripts that Judge Curry, who's deciding on whether Lindsey Halligan should live or die as a prosecutor, that she reviewed. Believe me, all of these seasoned judges are concerned about what happened. There's a number of moving parts in this memorandum opinion that he issued, which is 24 pages. I'll put up in Legal AF Substack, but it breaks down into 2 major arguments. One, the judge calls out the attorney-client privilege violations of the federal government in their prosecution of James Comey, that he had a lawyer. His name was Daniel Richman, a law professor at Columbia that also worked for the FBI, and that there was an attorney-client privilege relationship that existed, and the government trampled over that privilege and even used the Richman communications as the bulwark or the centerpiece of the grand jury presentation. And the judge has a problem with that, but he really has a problem. And let me read it to you about what happened in that grand jury room. This is all secret. Now, he's had certain aspects redacted, so we'll have to piece it together. We'll do that here on Legal AF. Take a minute, hit the free subscribe button. We're well on our way to hit 1 million in the next 2 or 3 weeks with your help of subscribers. Okay, let's turn to page 15 of his order. Having been requested by the government to review the grand jury materials. Let's stop right there. The government said to Fitzpatrick, we don't think there's any reason to turn the grand jury materials over to the defense. You should look at it first. Judge says, I'll be happy to. That process is called an in-camera review. So in-camera means only the judge gets to see it. Having been requested by the government to review the grand jury materials, Magistrate Judge Fitzpatrick says the court has identified 2 statements by the prosecutor, that's Lindsey Halligan, to the grand jurors that on their face appear to be fundamental misstatements of the law that could compromise the integrity of the grand jury process. One has to do with the Fifth Amendment. One has to do with the Sixth Amendment. Is it shocking to anybody? Lindsey Halligan was a federal prosecutor for like 72 hours. She'd never really been in federal court, and she'd never been a prosecutor before, and they sent her in alone. meaning Donald Trump and his Department of Justice left her twisting in the wind. She didn't even have, what was Todd Blanche doing, the number 2 in the DOJ? What was Pam Bondi doing? What was Stan Woodward, the number 3? They couldn't go down and sit with her and babysit with her? When I've had young lawyers who are handling a matter for the first time, I second chaired them. Where were they? Nowhere. So he says the first one is, and we'll have to piece this together, first, after having advised the grand jurors that the prosecutor, Lindsey Halligan, was their legal advisor, which is sort of true, the prosecutor stated something else. Here's how I can piece it together. The prosecutor's statement that blank is a fundamental and highly prejudicial statement of the law that suggests to the grand jury that Mr. Comey does not have a Fifth Amendment right not to testify at trial. I'm going to piece it together. She must have suggested to the grand jury that you'll have to ask Mr. Comey what this means because I only know what I know. He'll have to give you the rest of those facts. But as any first-year law student knows, as any well-versed American citizen on legal AF knows, a person is presumed innocent unless proven guilty, and they have a Fifth Amendment right not to testify and to make sure the jury doesn't hold that against them. They have a Fifth Amendment privilege not to self-incriminate, not to testify against themselves. She blew it. She told them you'll have to ask Comey. The prosecutor's statement, Judge Fitzpatrick said, ignores the foundational rule of law that if Mr. Comey exercised his right not to testify, the jury could draw no negative inference from that decision. She left them thinking that he had to testify, and if he didn't, there could be a negative inference, which turns the whole thing on the upside down. He cited a case from the United States Supreme Court back in 1965, Griffin versus California, holding that the Fifth Amendment forbids either comment by the prosecution on the accused's silence or instructions by the court that such silence is evidence of guilt. And she can't say, well, it was just the grand jury, because that infects the entire process, including the indictment. Then the second statement that he didn't like, and he said was a foundational misstatement of constitutional law in the criminal arena, is something that has to do, we call it burden shifting. She inadvertently or on purpose shifted the burden, acting like he had the burden to do something when the entire burden of proof is on the prosecutor to prove beyond a reasonable doubt. Here's what the judge said on that on bottom of page 15. The prosecutor's statement that blank, I'll put it together for you, may have reasonably set an expectation in the minds of the grand jurors that rather than the government bear the burden to prove Mr. Comey's guilt beyond a reasonable doubt at trial, burden shifts to Mr. Comey to explain away the government's evidence, which he has no obligation to do. She doesn't understand basic constitutional law in this area. And he cites a case, Victor versus Nebraska. In addition, he says on page 16, the statement by the prosecutor was made in response to challenging questions from the grand jurors. The grand jurors were smarter than Lindsey Halligan, the context of which suggests that the grand jurors may have reasonably understood the prosecutor to mean that if she could not satisfactorily answer their questions in the room, then Mr. Comey would blank answer these questions at trial. I mean, that's pretty obvious. That blank didn't help out Halligan there. Second, the prosecutor told the grand jury that there was blank. That statement clearly suggested to the grand jury that they did not have to rely only on the record before them to determine probable cause to indict, but could be assured the government had more evidence, perhaps better evidence, that would be presented at trial. You can't do that, Lindsey, in a grand jury proceeding. He then goes on and says, and she had other problems in presenting not one, but two indictments to the magistrate judge. You can only have one true bill of indictment. It was so difficult, he says, that the magistrate judge at the time, not him, had to ask the jury foreperson and the prosecutor to unwind the procedural knot, which also makes her a liar, because she said in her filing with Judge Curry that she had no contact with the grand jury after that certain point when the transcript was missing 2 hours of proceedings. She said that's when they were deliberating. That's not true. They were back in front of the magistrate judge, and where's the record of that should have been turned over? Judge takes that on. Judge Fitzpatrick, he says on page 17, the second indictment was a new indictment, and therefore the undersigned concluded, after reviewing the grand jury transcript, that the prosecutor would have been presented the second indictment to the grand jury for consideration before it was returned in open court. In other words, that she went back in and got the second indictment. It now appears that may not have happened because she didn't have time to go back in, because she said in her Curry affidavit that she never went back into the grand jury. He says in footnote 11, if the court is to read the prosecutor's declaration as suggesting that there was no contact between any government official and the grand jury after 4:28 p.m., then it begs the question of how the then first assistant learned, and that's Maggie Cleary, who got fired, learned that the grand jury had refused to indict on one count, and how the first assistant knew which count had been rejected to the grand jury all before the indictment was returned in open court. You're a liar. Here's what the judge concluded about these attorney-client privilege problems and the problems of misinstructing the grand jury. He made conclusions. He made 11 of them as required by Judge Nachmanoff. Let me give you the highlights. He said, first, the facts established on page 20. The facts establish a reasonable basis for the defense to challenge whether the Richmond warrants, that's Daniel Richmond, the attorney, were executed in a proper manner and consistent with the Fourth Amendment. The facts establish a reasonable basis for the defense to challenge whether the government exceeded the scope of those search warrants by seizing things that were not in the search warrants approved by a judge. The nature and circumstances surrounding the government's potential violations of the Fourth Amendment and the court orders establish a reasonable basis to question whether the government's conduct was willful or reckless disregard of the law. Then it goes to the disclosure of potentially privileged information to the grand jury. The 10th finding is that the prosecutor made statements to the grand jurors that could reasonably form the basis for the defense to challenge whether the grand jury proceedings were infected with constitutional error. The grand jury transcript number 11 and recording likely do not reflect the full proceedings because, although it is clear the second indictment was prepared and presented to the grand jury, the transcript and audio recordings of the proceedings do not reflect any further communications after the grand jury began deliberating on the first indictment. That kills them in the case with Judge Curry. And then makes these findings, turning over the grand jury materials to the defense. He says in his conclusion, the court recognizes that the relief sought by the defense is rarely granted. That's to get the grand jury materials. However, the record points to a disturbing pattern of profound investigative missteps that led an FBI agent and a prosecutor to potentially undermine the integrity of the grand jury proceeding. Therefore, the defense's request for grand jury materials is granted. So now the defense has the grand jury materials, and they will be filing, I assure you, a motion to dismiss the indictment for all of the constitutional infirmities pointed out by Judge Fitzpatrick. Later this week, there's going to be another hearing about whether this indictment survives a motion to dismiss based on vindictive prosecution. But Halligan's got a problem. She's got an eye, and so does Pam Bondi. This judge has effectively said they lied to Judge Curry several days ago when they filed their new affidavits and declarations. And I agree. Until my next report, take a moment, hit the free subscribe button, come over to Substack. We're on the Legal AF Substack. I will post this order, this memorandum opinion for you to read for yourself. Consider becoming a paid member there as well. Till my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.